Every day in the USA, people find themselves in court.
Why are you threatening me with an unfair?
Because I don't know why you're talking to me.
Counsel, this is most absurd.
Okay, all right. You're gonna come this close to contempt, so I'm gonna tell you just to be quiet. I'm 30 days. 30 days. He's got 30 days contempt. I told him to be quiet. He can keep talking if he wants. You want to keep talking? You want to keep talking?
You want to answer your question? You're asking me questions.
Mr. Collins, please.
Why do you want to answer?
He's got 30 days contempt. Take him out. I've given you the schedule. That's what we'll do. This is adjourned to the 31st. Court does call the case, People versus Sean Caldwell.
Your Honor, Jonathan Emmons on behalf of the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Caldwell.
All right,
Sean Rudolph called.
all right. We ready to proceed on this matter? There is the motion.
Your Honor, there is a motion that was filed by the previous attorney handling this case. Essentially, that speaks to the victim's statements to the officer pursuant to forfeiture of wrongdoing. I think that they're also admissible under 768.7C. So there's multiple ways for these statements to come in, but I'm prepared to argue the motion as it was
What
filed.
is this case before me? Oh, because he was in custody. That's why. All right.
Your Honor, if I may approach with Defendant's Exhibit 1, which is a printout that indicates that the complainant has a bench warrant. And with this,
Out of what court?
out of the 14B District Court. And Your Honor, it does, so our full argument in terms of the exhibit, we have other arguments as well, but in terms of the exhibit, is that Mr. Caldwell is not the cause of the wrongdoing. In reviewing the documents with regard to the bench warrant, Mrs. Caldwell was arraigned on or about September 28th of 2022.
I'm sorry, say it again. Tom.
She was arraigned on or about September 28th of 2022. She stood mute and that the court scheduled a pretrial for her, attend the next pretrial date, which was also in 2022. She attended a pretrial November 16th, 2022. And another hearing was scheduled for, pardon me, I want to say one more thing about that. In terms of this November 16th, 2022 date, it does appear that at the scheduled pretrial, that not only was another pretrial scheduled, but also I believe a show cause hearing was scheduled. Both of these matters were up on January 18th this year, and Mrs. Caldwell failed to appear. She did appear, as I stated, at least 2 other times, both times via Zoom, and would have been aware of this court date when she failed to appear, and likely is aware that there is a bench warrant. I do have that if you're on.
I'm sorry, we're saying that the last day was January 23, right?
Yes.
Yeah.
And that being the date that the bench warrant was issued.
And so your indication is, or you're indicating to the court, at least, that the only reason she's not here is because of the.
I'm indicating that on the papers that Mr. In terms of the pleadings that have been submitted by the prosecutor, that they are not able to show by a preponderance of the evidence all 3 of the things that are required for 804B6, which is that Mr. First wrongdoing, that wrongdoing was intended, and I'm specifically talking there that the wrongdoing did procure the unavailability. My argument is that there are that they cannot show that by a preponderance because there is, in fact, this warrant for her arrest, and that would make perfect sense for her not to be here.
But there were numerous phone calls, correct?
That is correct, Your Honor. However, just the fact that there are phone calls, and I go through a portion of the phone calls.
Pardon?
And I can discuss the phone calls. But just the fact that there are phone calls, which are a bond violation, does not mean if there were that necessarily is the reason that she's not here. They do have to show by a preponderance that there was wrongdoing that was in some way coercive, threatening, or with regard to her appearance, and that wrongdoing in fact caused her not to be here by a preponderance of the evidence. And that is pursuant to People v. Burke.
I understand that. And I guess my question is, have we heard all of the phone calls?
I have heard a majority of the phone calls. I actually received probably well over 100 links in terms of calls. The various links are from a multitude of different dates, and they are not in any order. There's one that refers to the 20th in terms of a conversation, and it's not.
Well, my issue is I'm not so much concerned about the date as what was said. And that's why I'm asking where they listened to.
Ms. Caldwell indicates that she called to the Washtenaw County Sheriff's Department. One of those times, she indicates that she spoke to who she said was Miss Justice, but I believe that's probably Sergeant Justice. And so there were multiple occasions where she could have reported some concerns to law enforcement.
Okay, but I'm not even worried about whether or not she reported it. What I'm worried about is, or what the court's inquiry is during the course of these phone conversations, is there conversations that would lead to at least some inference that she shouldn't appear, or some type of coercion, something in these phone calls?
My interpretation
Okay.
in regard to the particular statements, and in speaking with my, that there is a breakdown, there's concern and things like that, but not a specific statement, do not come to court. No, there is not.
Well,
Or is there a statement?
but Ms. Gaines, you know as well as I do that you don't often get that don't come to court. Sometimes you get that, but that's not.
There is a conversation where he says for her to come to court. But I'm, in terms of answering the specific statements that are alleged to have been preventing her from coming to court, in terms of the whole context of the conversation, there are not.
Response.
When I listen to the majority of the most relevant phone calls, the first couple of phone calls come in right after he's arrested. And I think that that's important. And I think it's instructive. And so that those phone calls essentially tell the victim, court can't stop me. The police can't stop me. I'm still going to be in your life. And to that point, throughout the first part of the phone calls, there's a lot of I love yous. There's a lot of future planning. They're even talking about what I think that they're undergoing an eviction process, if I understand it correctly. And they're worried about what they're going to do with the cats, right? But then we get into the harm. He says, figure out which direction we're going, start making an expletive plan. I can beat you up either way. I'm going to beat you up. I'm going to rape you. The victim warns the defendant, don't say anything over the recorded call. The defendant replies, I don't give a, if the police find out I'm talking to you, then I'm really expletive. That statement is instructive. We already have him reintroducing himself back into this woman's life on the heels of the incident that occurred on August 5th, right? By August 9th, he's already making these statements. Look what I'm capable of doing, and you know it. By August 15th, he kind of reiterates some of those points. We see that in paragraph 5. One of the calls that's not listed in this report, but was made mention to, that about him telling her to come to court. The court would like, it's about 30 seconds. I can play that part where he tells her to come to court, because what he says coming to court, but it's the tone in with which he says it that I think is more instructive. I've got it pulled up right here, what would like to listen to.
Sure. Why not?
You make some money and you want to go fucking blow money for not making money with the person who would be there to the fucking end. Okay. Don't grab fucking money, show up in my court day. Show the fuck up, bitch. You paid her, show the fuck up. Show up or I'm never talking to you.
I'm never talking. I literally meant I wanted her to show up. I either pursue this or I don't even talk.
You may not want to keep saying stuff.
So to me, obviously,
I let you finish.
I'm just letting, I'm sorry.
It's okay. Go ahead.
thank you. So to me, that last part, it's almost, you hear the tone. And to me, I like to think that I'm somewhat reasonable. Court may disagree with that. But to me, that's come to court. I dare you. And we think about that on the heels of the statements, I'm going to beat you, I'm going to rape you. And that statement, go ahead, bring to court. When we look at the coercive control that's employed from the very beginning to the very end of that phone call, it seems to me his intention is to try to avoid responsibility in whatever way he knows. And so to that end, I think that these calls are very tailored to procure, they were intended to do the wrongdoing. He admits that it's wrongdoing and that they did in fact procure that unavailability. And so for that reason, I think that the statements are admissible. Like I said, also, I think that they meet the criteria under 768.27C. The statements that are going to come in were all made to the officers at the time of the offense. They're corroborated by the officer's observations. So I think there's a number of ways that come in. The last point, that warrant was in January of 2023. This happens in August 5th. She had police contact on August 5th while still having that warrant out. It kind of undercuts the idea that she's afraid of coming in when she already had the contact with the police. So speculation on my part, I can see, but it's something I think worth thinking about.
Ms. Gaines, anything else?
Yes, perhaps I misunderstood Mr. Emmons, but I do want to say that my client is not admitting to wrongdoing in terms of anything that would be coercive or in any way of that matter. Simply violating the bond conditions is not enough for the wrongdoing. The wrongdoing, there has to be some showing that the wrongdoing itself is what is the cause, and that there was a specific intent to cause her not to be in court. All of the things that Mr. Emmons is mentioning, has been mentioning, are from August. However, a month later, or a little more than a month later, September 19th, is when we were scheduled for the preliminary examination, and she did not appear. There are hundreds of phone calls I would bet. However, I can't say for sure because they aren't labeled by date or any kind of order so that I can be certain, and they're mixed in, so I cannot, yes, Your Honor.
So, I mean, I guess, Ms. Gaines, what are you indicating? That
so-
you haven't had the ability to listen to all of them, which may
I have not.
frame a different context to what I've already heard?
Your Honor, that is what I believe, even from the ones that I have listened to, because I have listened to more than 2 calls. They are not there, as he states, there's the pressure of the eviction. There's what are they gonna do with the cats? There's a whole lot of things that are being discussed
Ms.
with
Gaines,
regard to the eviction.
Ms. Gaines, are you indicating to me that there may be calls after these calls that are referred to that lend a different context where
Yes.
he may have, but you don't know because you haven't been able to listen to them all? Is that what I'm hearing?
You're hearing 2 things, that I have not listened to all of them, and there are calls that it is after these 2 calls, because.
But Ms. Gaines, here's the problem, because I don't have a written response from the defense. There are all of these phone calls. Based upon what I see now, it's clear to me that there is some wrongdoing. But you're trying to tell me that if you were to listen to these calls, the court might come to a different conclusion. That's what I'm hearing from you. Is that right?
That is correct.
Okay. So if that's the case, I need a written response from the defense so that the people know which calls you're referring to. And I will adjourn this out 2 weeks and give you an opportunity to listen to all of them and get through it.
And if I may add one more thing, in terms of Mr. Caldwell. He did provide me with a letter that he received from her that is postmarked October 2nd of this year.
This is a week after I was supposed to.
Okay, see, so I can frame my own thing. You know, you gotta let your attorney do her job. She's very good at what she does, and you're not helping yourself. But if you want to keep talking, keep talking.
I am going to show it to the prosecutor. And in this card, there's a photograph, and there's also a statement of course, I want you to call. I hate not hearing from you. So I can do the written response if Your Honor needs some more information.
Well, hold it. I don't need any more information. I told you what I'd rule right now.
Yes.
You're indicating to me that there are other calls that may lead this court to form a different context to what was said. And so why does he keep talking to me? Is he done?
I believe so.
And so all I'm trying to do is to give you the opportunity to show that to the court.
If I could have one moment just to make sure that my client understands what's happening.
Ms. Gaines, you may want to mute that thing so that everybody in the world doesn't hear it. I can.
Yeah,
You should see those first.
I will ask. Your Honor, this matter has been adjourned previously, twice, and Mr. Caldwell does not want another adjournment.
Well, then I'm ready to rule on the motion and proceed now. I don't have a problem. That does not get to that issue.
I understand, Your Honor. Mr. Caldwell was requesting that I ask if you would see this,
If I would what?
if you would look at me.
But what does that, what would that tell me regarding this motion? Nothing.
I understand, Your Honor. If you're ruling that you will not look at it, then
There's no reason for me to.
I understand.
So then the other issue, and I want to make sure Mr. Caldwell understands, I'm prepared to rule on the motion with what's in front of me at this point in time. So that I'm real clear, I would be ruling that the people can proceed by forfeiture, meaning you're wrongdoing. Your counsel, in her way, has been asking the court that there are numerous calls that if she listened to them, may or may not lead the court to in another direction, not to allow this to proceed by forfeiture by wrongdoing. If it were, if she turns out to be correct, you need to understand that if I find that there's no forfeiture by wrongdoing and the alleged victim not appearing, the matter would be dismissed, which is what she is thinking about trying to get to. Whether she can get there or not, who knows? But if you don't want me to give the time for counsel to do that investigation for you, I won't, and we will proceed today. So if that's your choice, I just want you to clearly understand so that if it turns out that you're bound over to stand trial, you're not looking at anybody else in terms of that decision. You clearly would understand why this has happened. You understand that, Mr. Caldwell? That was a question.
Yeah, I mean, I do, it's just, I mean,
Okay, based upon what the court has said, because I'm just trying to be fair, do you want an opportunity to speak a couple minutes with your attorney in private so that you can figure out what you want to do? Okay. Since I ask questions and don't get answers, what I'm going to do, take him back. Ms. Gaines, go around, talk to him. I want to give him every opportunity to make decision, and it's okay because I'm not going to be home for breakfast the way this is going. Court does recall the case of People versus Sean Caldwell.
Your Honor, Jonathan Emmons on behalf of the people.
Joy Bean, Senior Assistant Public Defender, representing Mr. Caldwell, who's present in the courtroom.
All right. Okay. I believe what we're going to do is we're going to get an adjournment. My next date was the 31st. Miss Gaines has implored me, and I've relented to it. So you can thank her, sir. She told me that you wanted to have the next available date. And so we worked some things out. So what I will do is I will set the preliminary examination. I'll just go to Monday, the 23rd. So I'll adjourn the preliminary examination in this matter to October 23rd, 2023, 9 a.m.
9 a.m.
Yes, that will be in person. Does 9 work, Mr.?
Your Honor, I thought I heard a different time, so I sent the email to the officers anticipating that. I think I said 10, but I can just correct that.
You said 10 a.m.?
Yes, but I can correct it.
Well, we'll hear it at 10. Don't worry about it. We'll just do it at 10 a.m. I've got something else set at 9, so we can do it. We'll just do it at 10 a.m. That's before me in person. That way you don't have to send anything correct. All right, bond will continue. Okay, so 30 days. He's got 30 days contempt. I told him to be quiet.